Your Honor, today's date and time set for exam. As you may recall, you authorized Mr. Perry to be allowed to attend inpatient treatment. I was notified yesterday that he was taken to treatment from the jail to Sacred Heart in Richmond. They have informed me that they do not allow Zoom court procedures or any other way to facilitate him being here today. So he is not here. I do have proof of that treatment if you'd like to see it.
No, I believe.
This courtroom session opens with what looks like a routine procedural update, but underneath that calm tone, there's a lot more happening. Right away, you hear about a defendant being transferred from jail into inpatient treatment. That's a critical move. In the legal world, entering treatment can sometimes signal rehabilitation efforts, which courts often consider when deciding future outcomes. But here's the twist. He's not present in court, and the facility doesn't allow Zoom appearances. That immediately creates tension. Because in court, presence matters. Judges expect defendants to show up, physically or virtually, and when that doesn't happen, it can raise concerns about accountability. Now listen closely to how Judge Simpson handles this. He doesn't overreact. He doesn't escalate. Instead, why he asks one key question: how long will the program take? That's strategic. He's not just managing a schedule, he's assessing whether this delay is reasonable or if it's being used to stall the case. And this is where courtroom dynamics become interesting. The judge balances two competing priorities: the defendant's right to treatment versus the court's need to move the case forward. By choosing to adjourn instead of penalize, he signals something important. This court values rehabilitation, but only within limits. The real question now becomes, is this treatment genuine progress, or just a delay tactic? Stay with this case because moments like this often come back later with serious consequences.
How long is
the program maximum is 30 days. In what they sent me, they said their average time of attendance is anywhere from 10 to 21 days. So I'm not sure exactly. It's going to depend on how well he does while actually in treatment.
Well, why don't I do this? Why don't I adjourn it to my next date, which is the 13th, and if we have to go to another date, we can do that.
That's fine, Mr. Allen, let me actually so I can call off my witnesses.
So preliminary examination in this matter will be adjourned to January 13th, 2026, 9 a.m. That's before me.
Thank you, Your Honor. That's it for me today. So have a happy New Year.
Yes, and to you, sir. Court calls case People versus Corey Curtis.
Good afternoon, Your Honor. Rated people.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of the defendant Corey Curtis, who's approaching. Mr. Curtis, please state your name for the record.
Corey Curtis. As the date and time set for preliminary examination, after conversation with the counsel, we're going to humbly, respectfully request that this court adjourn this exam. There is
humbly. So that humble was coming from you or from defense counsel?
From defense counsel. She's more humble than I.
This moment might seem light, even comedic, but it actually reveals something deeper about courtroom psychology. When the defense uses the word humbly, the judge immediately calls it out. That's not random. Judges are highly sensitive to language, especially when it feels rehearsed or strategic. What you're seeing here is a subtle power dynamic. The attorney is trying to position their request, an adjournment, as respectful and reasonable. But the judge pushes back just enough to show he's not easily swayed by wording alone. Then comes the real issue. A key witness is unavailable because they're serving in the military. That's a legitimate reason, and legally, it holds weight. Courts generally accommodate such situations. But here's the catch. This delay benefits the defense. And anytime there's a delay, it can weaken momentum in a case. Witness memory fades, urgency drops, and strategy shifts. Notice how the judge still grants the adjournment, but not without injecting control into the situation. He jokes, he challenges, but ultimately, he sets the new date on his terms. This raises a question. When delays are justified, do they still change the outcome of a case? Because sometimes justice delayed doesn't just wait, it transforms.
Oh, I knew that. That's why I was curious as to where it was coming from. Go ahead.
There's been an offer that was extended as well as some additional conversation. As well, one of the people's necessary witnesses for staff. My understanding is he is away serving in the military right now and could not be present today. He could be present via Zoom if the court will allow that. Otherwise, I expect him to return, I want to say at 1 to 2 months, I believe is when it was expected to return.
Okay.
So that is correct, Your Honor. We have discussed the date of February 3rd on Your Honor's docket, if that pleases the court.
Man, why are people picking my day? What, is that my day?
It is actually.
It is? Did you tell him? Somebody gave him my date, because it's a secret. Okay, it's not a secret. People aren't supposed to know when I'm here or not. So February 3rd.
Yes, Your Honor.
Yes, please, thank you.
All right, I'll do it. Only because defense counsel humbly asked.
Thank you, Your Honor.
Preliminary examination will be adjourned February 3rd, 2026, 9 a.m. That is before me.
Thank you, Judge.
Thank you. Bond will continue.
Thank you.
Your Honor, just, I'm where, can I get the Zoom?
Did you just leave and your case isn't over yet?
This is one of those moments that instantly shifts the tone of the courtroom. A defendant casually starts walking out before the case is officially concluded, and the judge catches it immediately. In court, that's a serious misstep. Even if it's a misunderstanding, it can be interpreted as disrespect, and judges do not tolerate that lightly. What's interesting here is that the defendant quickly corrects himself, saying, "My bad." That response matters. It shows this wasn't defiance, it was confusion. But let's break this down legally. Courtroom decorum isn't optional. Defendants are expected to remain attentive and follow proceedings until explicitly dismissed. Walking away early, even unintentionally, can influence how the judge perceives your attitude moving forward. And perception is everything. Judges are constantly evaluating not just facts, but behavior. Respect, attentiveness, and compliance all factor into future decisions, especially when it comes to sentencing. So here's the key takeaway. Small actions in court can carry big consequences. The question is, will this moment stick in the judge's mind later?
You say, "Ooh, my bad"? He said it was. So he just turned his back to me and walked out? His attorney had talked to him about that.
We'll have
If the trooper says when we appear via Zoom, can I get that Zoom information from Ms. Whiteling when we get a little bit closer to that date?
Yes, if it's going to be necessary, certainly you can get that from me, and
Thank you.
we'll provide that.
No objection to Zoom.
Okay, very good. Thank you. Now you may go. Court calls the case, People versus Joseph McCalla.
Good afternoon, Your Honor.
Counsel have another one. Did you have another one, Counsel?
She does.
She does.
It's this one.
That one. Oh, okay.
After, okay.
Yeah.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. McCalla. State your names.
Joseph McCalla. Okay.
Your Honor, they can set up, this and the people are unable to proceed.
And the defense would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Just like that, case dismissed. But don't let the speed fool you. This is what's called a dismissal without prejudice, and that detail changes everything. Legally, this means the prosecution can refile the case later. So while the defendant walks away today, this is not a permanent victory. It's more like a pause. Now, why would the prosecution be unable to proceed? It could be missing evidence, unavailable witnesses, or procedural issues. Whatever the reason, it signals a lack of readiness. And in court, timing is critical. For the defense, this is a win in the moment. But strategically, it's uncertain. Because if the case comes back stronger, this temporary relief could turn into a tougher battle later. This raises a bigger question. Is it better to face a weak case now or a stronger one later?
On the defendant's motion.
Thank you, Your Honor.
Thank you. Court calls case, People versus Nikita Jackson.
Good afternoon, Your Honor.
Good afternoon again, Your Honor. Alexandria Taylor appearing on behalf of defendant Nikita Jackson, who is approaching. Ms. Jackson, please state your name.
Nikita Jackson.
Thank you.
And Your Honor, similarly on this case, we're respectfully requesting an adjournment. We can get that same date in order to keep the cases together. People would appreciate that greatly.
Does that sound humbly? I bet you it counts. If she told me, I'd probably feel like really warm. Cook, he just rubs me the wrong way. I will adjourn. Preliminary examination will be adjourned to February 3rd, 2026, 9 a.m. And that is before me.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Happy New Year.
And to you. Court calls the case of the people versus Raul Fernando.
Andrew Childers appearing on behalf of.
Good afternoon, Judge Aida Sparhich, on behalf of Mr. Raul Fernando, who is approaching and now standing to my right, Judge.
Your name, sir?
Raul Fernando.
Thank you.
Today's the daytime set for examination. Is this time people will be moving to dismiss this case without prejudice, file and non-cause?
No objection on our end, Judge.
Case is dismissed.
Thank you, Judge. Happy New Year to you and your staff.
And to
Steve.
you. Court calls the case of the people versus Robert Jameson.
Good afternoon, Your Honor. Raymond Cook, the people.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Jameson.
Where is it?
The date and time set for preliminary examination. I believe Mr. Jameson had a PCC earlier today where the court issued a bench warrant. In full candor, the people were not able to proceed today.
In full disclosure to the court, Your Honor, I discovered at about noon that Mr. Jameson actually had gotten released from custody and missed his morning court when I went to try and
Yeah, my
visit
staff was telling you that time and time again, but you weren't listening. But go ahead.
This is where the courtroom energy spikes. The judge is no longer joking. He's asserting authority. What triggered this? A breakdown in communication. The attorney failed to act on information already provided by the court staff. And that's a major issue. Judges rely heavily on their staff, and when their credibility is questioned, even indirectly, it becomes personal. Listen to how Judge Simpson frames it. He doesn't just correct the attorney, he reinforces trust in his team. 99.9% of the time, they're right. That's not just a statement, it's a warning. Then comes the consequence, a bench warrant with a $25,000 cash bond. That's serious. It means the defendant is now actively wanted and the financial barrier to release is high. This moment highlights a harsh reality. Mistakes in court don't just stay on paper. They escalate fast.
Well, Your Honor, I just wanted to verify it with all the
Yeah, no. My staff was telling you. You know, and it's a funny thing. I have the greatest staff in the world. And they tell you something. 99.9% of the time, they're right. You can take it to the bank because, quite frankly, I trust them more than any other people running around this planet. And when they tell me something, I take it to the bank. You might want to learn that, counsel. Bench warrant will issue in this case, bond $25,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor. The only other part I was going to add is I also have no contact information from Mr. Jameson. So if he is picked up, I'd ask if the court could, maybe try and get a phone number or something for him. I assume he'll be in custody.
Well, the magistrate, they'll do what they can.
Thank you, Your Honor.
Thank you. Court calls case, people versus Yasina Miranda.
Good afternoon, Your Honor. Raymond Cook, the people.
Alex Warren Green on behalf of Miss Miranda.
Your name?
Yesenia Miranda.
Okay, I almost got it right. Say it again. the first
Yesenia
name?
Miranda.
Okay, all right. Because everybody's been yelling at me because I mispronounced people's name all day. So I'm a little sensitive.
Your Honor, this is the date and time set for preliminary examination. At this time, people are unable to proceed counts 2 and 3.
The defense would move to dismiss, Your Honor.
All right. Are you moving to remand on counts 2 and 3?
Yes, Your Honor.
All right. Then what I will do.
This is one of the most defining statements of the entire session. The judge lays out his courtroom philosophy clearly. Respect and preparedness are non-negotiable. What's happening here is a partial win for both sides. One count is dismissed, but others are sustained and moved forward. That balance shows the court is weighing both procedural fairness and accountability. Notice the tone shift. This isn't casual anymore. It's controlled, direct, and authoritative. The judge is setting a standard, not just for this defendant, but for everyone in that courtroom. And here's the deeper layer. Judges often use moments like this to send a message beyond the case itself. It's about maintaining order, consistency, and credibility in the legal system. So ask yourself, does strict courtroom discipline lead to better justice, or does it risk overlooking individual circumstances?
I'll continue the defendant's not guilty plea as to counts 2 and 3. Count one will be dismissed on the defendant's motion. I'll set a pretrial on this matter.
January 22nd, at 9 a.m. to 4th of Washington.
January 22nd, 2026, it's at 9 a.m.
Yes.
9 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Derek Shipman.
Brian Bowling on behalf of Mr. Shipman, who's approaching, Judge. Hey, Derek, state your name.
He knows it.
Derek Shipman.
Thank you.
Judge, we have a resolution in this matter. There should be a signed plea form in the court file as well as a
Yes.
signed advice of rights.
Uh,
Or a advice of rights I signed on Mr. Shipman's behalf with his consent.
All right. The plea form indicates that the defendant is going to be pleading no contest. Did I get this, please?
Now the case shifts into something far more serious, a plea deal. And specifically, a no contest plea, which many people misunderstand. This is not the same as pleading guilty, but in practice, it has nearly the same effect. Here's the key. When a defendant pleads no contest, they are not admitting guilt outright, but they are also not fighting the charges. The court will still treat them as guilty for sentencing purposes. That's exactly what the judge is carefully explaining here. Why would someone choose this? Strategy. A no contest plea can sometimes protect the defendant in related civil cases or reduce exposure in certain legal situations. But make no mistake, this is still a major decision. The defendant is giving up the right to trial, the right to challenge evidence, and in many cases, the right to appeal. And notice how Judge Simpson walks through every consequence step by step. This is not optional. Courts are required to ensure the defendant fully understands what they are giving up. If they don't, the plea can be challenged later. This moment is critical, because once that plea is entered, there's no going back.
Yes.
I did. No contest to 3 charges. Count 2 of operating while intoxicated, the 93-day offense. Count 3, driving while license suspended, 93-day offense. And count 4, disorderly person, a 90-day offense. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Judge.
May I have him sworn?
You solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Derek Shipman.
Sir, it is this court's understanding that you're going to be pleading no contest to 3 charges. So
Yes, sir.
understanding?
Yes.
First charge is count 2 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, a $300 fine plus, a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order your vehicle forfeited, or could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
All right. Count 3 is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir?
Yes.
And count 4, disorderly person, is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
This exchange might sound repetitive, but it's actually one of the most important safeguards in the legal system. The judge is confirming again and again that the defendant understands exactly what's happening. Why so many confirmations? Because plea deals must be knowing, voluntary, and intelligent. That's the legal standard. If any part of that is missing, if the defendant was confused, pressured, or misinformed, the entire plea can be invalidated. Listen closely to the structure. Do you understand the charges? Do you understand the penalties? Are you doing this voluntarily? Each question builds a legal shield around the plea. And here's where it gets real. Once the defendant says yes to all of these, they are locking themselves into the outcome. There's no trial, no jury, no second chance to argue innocence. So the real question becomes, is this a smart legal move or a forced compromise?
All right. 2 things about it. I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes.
All right. Or her successor, I should say. Still wish, and the basis for the no contest plea count?
Lack of recollection, Judge.
All right. Still wish to plead no contest, sir?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
No contest.
To the charge of driving while license suspended, denied, and or revoked, how do you plead?
No contest.
And to the charge of disorderly person, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had an advice of rights form signed on your behalf?
Yes.
All right. Any questions regarding any of those rights?
No.
You understand that by pleading no contest, you're waiving or giving up the rights on that form?
Yes. Oh, excuse me. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay, were you on probation or parole at this time?
No, sir. No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 243152. Any objection to the court having reviewed that report?
No objection.
No objection for the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
This warning is one of the most powerful moments in the plea process, and it's easy to overlook. The judge is telling the defendant something very direct. Even after your plea is accepted, your behavior still matters. If you mess up before sentencing, the court can change everything, and you won't get your plea back. That's huge, because many defendants think once the plea is done, the deal is locked in. It's not. The court still holds control until sentencing is complete. This is about accountability. The system is saying, if you want the benefit of this deal, you need to prove you deserve it right now. And this creates pressure, because even a small violation, missing a requirement, breaking a condition, can trigger harsher consequences. So here's the tension. The defendant has agreed to the deal, but now they have to live perfectly within the court's expectations until sentencing.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have...
I'm not aware of any, Judge.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
So is the defense, Judge.
Court will accept the defendant's no contest pleas to counts 2, 3, and 4. Count 1 is dismissed. A pre-sentence investigation and report is ordered, as well as screening and assessment at 15th District Court probation. Sentencing in this matter will be January 20th, 2026. What time? 9 a.m. before Judge Valvo or her successor. Bond will continue.
Thanks, Judge.
Thank you, sir.
Happy New Year.
And to you, sir. Court does call the case, People versus Abbas Safadine.
Andrew Childers, appearing on behalf of the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Safadine. Ask you to introduce yourself. Boss Safadine, Your Honor.
All right, thank you. All right, what are we doing?
We are here for a negotiated guilty plea.
All right, I have a plea form before me indicates that the defendant will be guilty to the charge of larceny by false pretenses under 200, 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is also the agreement that the prosecutor will recommend or is okay with the height of sentence, and restitution is agreed at $500. That's
That's correct, Your Honor.
Okay, the sentencing judge waiver box is not checked, but I view that as an oversight, so I'm going to check that box.
That is purely my oversight, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name.
boss happy.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the offense of larceny by false pretenses under $200.
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
You
Your Honor.
understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead? How do you plead?
What do you?
Guilty or not guilty?
Oh, I plead guilty.
Yeah, right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No,
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
March 16, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do regarding, or what'd you do that makes you think that you're guilty? Let's do that.
I used the card that was not mine to pay for the parking structure.
To do what?
To pay for the parking structure.
This is the moment where the facts come out, and it's more nuanced than expected. The defendant admits to using a card that wasn't his. That alone establishes intent. But then we learn something surprising. The transaction was rejected. No goods or services were actually obtained. So what does that mean legally? It shifts the nature of the offense. Instead of a completed fraud, this becomes an attempted or improper use case. And you can hear the judge adjusting in real time. He recognizes that the original charge may not perfectly fit the facts. That's why he moves toward a higher charge version focused on the act itself, not the outcome. This is a perfect example of how fluid courtroom decisions can be. Charges aren't just static, they evolve based on what's proven in court. It also raises an interesting question. Should someone be punished the same way if the crime didn't fully succeed?
Okay. So the card was not yours?
Yes.
You didn't have any of the owner or device holder's permission to use it?
No, I just did.
And you did not inform wherever you were using it that you didn't have permission?
No.
Right? And because of your use, you obtained goods or services?
No.
You didn't get anything?
No.
What happened?
Your Honor, it was rejected, but he still used the financial transaction.
Got it. Okay, but he didn't get anything from it?
No.
Okay, then I'd have to certainly take it as to the higher charge, which is actually the use, because there was no value done. Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and your time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, that number one, the court would not be bound by any evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea to count 2, particularly under the higher offense version. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be January 30th, 2026, 8:30 before Judge Perry.
Your Honor, is there any chance of another date? I'm looking forward to being right here on January 30th at 9 a.m.
Oh, I'm sure there's, another day. I don't have it. So what you can do is I have to give you this date. You can contact 15th. They'll be more than happy, I'm sure, to accommodate another date.
This might seem like a minor scheduling issue, but it reveals something important about how courts operate. The defendant asks for a different sentencing date. The judge doesn't deny the request, but he also doesn't take responsibility for changing it. Instead, he redirects them to the appropriate court system. That's procedural discipline. Judges operate within structured boundaries. They don't just adjust things informally, they follow process. And this matters because it keeps the system consistent. Every change, every request, every adjustment has to go through the proper channel. It may feel rigid, but that structure is what prevents chaos in a system handling thousands of cases.
All right, thank you.
Thank you. The court, for its part, also does not believe there's a conflict other than Michigan court rules. Other cases decided thereunder to the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Jason, is it Elk? It's you. Oh, come on up. Who's your attorney? Mr. Goldman. He stepped out. All right. Well, I'll pass it. Okay. Court does call the case of people versus Reginald Sims.
They also stepped out.
Good morning. Okay, so I'll pass that one too. Third time's a charm. Court calls the case people versus Chanel Griffin. And Miss Pate is here, and I think your client.
Assistant Public Defender, on behalf of Ms. Griffin. Oh, can you please state your name for the record, ma'am?
I'm here.
State your name.
Chanel Griffin.
Go ahead.
Thank you, Your Honor. Me and Ms. Griffin had the opportunity to review the PSI. We only have one update. I believe since the report has been written, Ms. Griffin states to me she has taken care of her outstanding warrants. Outside of that, we have no corrections to the report, and we would respectfully request the court adopt the probation's recommendation for the sentence.
All right. Ms. Griffin, anything you want to tell the court before I impose sentence? Question mark.
Ms. Griffin, was there anything you wanted to say before the judge imposed sentence?
Oh, I'm sorry. No, sir. I didn't. Oh, maybe you guys can hear me. I'm sorry.
Sentence of the court, $480 fines and costs, 93 days in jail, suspended. When can you pay the fines and costs, ma'am?
This sentencing is quick, but it's packed with meaning. First, notice the structure: fines, jail time, and then suspension. The 93-day jail sentence is suspended, which means the defendant won't serve it, as long as they comply with conditions. That's conditional leniency. The court is giving the defendant a chance, but it comes with expectations. Then comes the payment timeline. The defendant asks for 90 days, but the judge shortens it significantly. That's not random. Judges often test a defendant's willingness to take responsibility immediately. By tightening the deadline, the court is signaling urgency. This isn't something to delay, it's something to handle now. So while this may look like a light sentence, it's actually a structured test. Comply, and you stay free. Fail, and those 93 days become very real.
I can have it paid off in, I say, like 90 days.
She say 90?
I believe so, Your Honor.
90? Like 90? 90,
yeah.
Well, you're going to have to do it a little bit sooner than that. I'll give you to February 28, 2026.
Okay.
All right. Thank you.
Thank you so much.
Thank you, Your Honor. Thank you, Ms. Griffin.
Thank you.
Court calls the case people versus Ethan Ryans.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Ryans, who appears on Zoom. Clerk, please state your full name for the court.
Good morning, Ethan Ryans.
Go ahead.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review both the assessment as well as the recommendation from probation, which I have had the opportunity to review with Mr. Ryans. He does just have one request as to the sentencing recommendation. We're asking if the court would consider not imposing the twice weekly, or in the alternate, consider possibly only once weekly of the AA classes. Mr. Ryans does state to me that he continues his enrollment in school. It's my understanding that he's taking 16 credit hours as well as working during this time to earn money. He does have some concerns about both keeping up his schooling with his job if he is attending 2 of those per week. To my understanding, he has been completely compliant on his bond, and this is the first offense of something of this nature. Outside of that request, Your Honor, we would ask the court to adopt probation's recommendation.
Sir, is there anything you want to tell me before I impose sentence?
No, sir. Pretty much as my attorney has stated, I've, tried my best to stay compliant with my tether. I have quit alcohol earlier this year in April, and I plan on keeping that track. So,
where are you in school?
Washtenaw Community.
What are you going to be when you grow up?
Currently, I'm studying business administration and looking to transfer over to Michigan State with fall 2027 enrollment.
To where?
Michigan State. That's where I'm looking to transfer to for management.
Why? For God's sakes, why?
A lot of people feel like I'm betraying you, Mish, but honestly, I feel like the competitiveness.
That may get worse. Why are you going to transfer into state?
I feel like the environment is just a little bit better for me. The competitiveness with
Have you ever been there?
No, I took a tour there back when I was 17.
You took a tour at 17, and
Yes,
it took
sir.
forever, didn't it? None of the buildings are together. The whole place is like spread out.
Yeah, the entire city is the campus.
Yeah. So you really want to be a Spartan?
Yes, sir.
Well, we might have to change this sentence.
This moment adds humor, but it also humanizes the courtroom. The judge jokes about the defendant choosing a rival school, and the tension briefly lifts. But don't miss what happens right after. The tone shifts back to serious, and the sentence is delivered with precision. This balance, light humor followed by firm authority, is a hallmark of experienced judges. It keeps the courtroom controlled without becoming overly rigid. Then comes the actual sentence. 18 months probation, financial penalties, mandatory treatment, and strict behavioral conditions. This is rehabilitation-focused sentencing. The goal isn't just punishment, it's correction. The court is trying to change behavior, not just penalize it. But make no mistake, this is still a heavy sentence, because every condition is a potential point of failure. And that leads to the real question. Can the defendant actually meet all these requirements? Or is this setting them up for another violation?
All right, young man. Well, I wish you all of the best, and I'm just teasing with you. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. The court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court that you are placed on 18 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can you pay that?
Give me about 48 hours, please.
48 hours?
Yes, sir.
Oh, I like you. All right. I'll tell you what, pay it by the 26th, okay?
Yes, sir.
Has the Spartan never told me, yes, sir? No, he's going to be the first.
I have.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victims' impact panel attendance to probation. You continue the scram tether an additional 30 days in lieu of 5 days in jail. All order 93 days in jail that is suspended. Thank you.
Thank you.
Thank you, Your Honor.
And sincerely, young man, good luck to you.
I appreciate you. Thank you.
Thank you, Mr. Ryans.
Thank you.
Court does call the case, People versus Brendan Williams.
Hello.
There he is. Assistant Public Defender Natalie Pate with on behalf of Mr. Brendan Williams. Sir, can you please state your full name for the court?
Brendan John Williams.
Thank you. Your Honor, today's the day and time set for sentencing. Likewise, I had the opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything Ms. Blair?
Your Honor, Teresa Clare on behalf of probation, I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is starting on probation with me on another matter. This case is not a violation of that case. It happens prior to being sentenced.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation or a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment.
This is where sentencing philosophy becomes crystal clear. The judge explicitly states this is not a serious misdemeanor, yet still chooses to impose probation and structured conditions. That tells you everything about how this courtroom operates. This isn't about the severity of the crime alone. It's about risk management. The court is looking at patterns, behavior, and potential future harm. Even low-level offenses can trigger strict oversight if the judge believes intervention is necessary. Notice the language: promote change, prevent recidivism, and monitor compliance. That's the framework. The court is not just reacting to what happened, it's trying to control what happens next. And then comes the financial component: fines, costs, and recovery fees. These aren't random numbers. They serve two purposes: accountability and deterrence. And the defendant must feel the consequence, both behaviorally and financially. But here's the reality: probation is often harder than it looks. It's not freedom, it's controlled freedom. Every rule, every condition, every payment becomes a checkpoint. So the question is probation a second chance, or just a slower path to failure?
So for the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a dual diagnosis programming, including all recommended aftercare, with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. All right. Thank you, sir.
Thank you.
Thanks, Mr. Williams.
What?
Can you do your recall?
You're messing up my holiday.
I know, I apologize.
What? No, you stay here. I'm going to go home.
This moment might feel chaotic, even humorous, but it reveals something important about courtroom control. Cases are being recalled, attorneys are missing, defendants are waiting. This is real-world court flow. It's not always smooth, and judges have to manage that unpredictability in real time. What stands out here is how the judge maintains authority even in disorder. He doesn't lose control. He keeps moving, keeps calling cases, keeps the system functioning. This is the unseen side of the legal process. Behind every decision is a constant effort to manage time, people, and logistics. And here's the key takeaway: justice isn't just about rulings. It's about maintaining order in a system that can easily become chaotic.
You want me to recall both? Is everybody here now? Because everybody like bolted before I came in.
We're ready on Echo.
I know. I see you. You see that? I was asking you and he just decided to talk. Court calls the case, People versus Jason Echo. Should have heard, I know you're ready. You should have heard what your client said. I don't know why he's not here. It was horrible.
Good morning, Your Honor. Robert Goldman, P81222, appearing on behalf and alongside Jason Eckel, President of the courtroom this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel.
All right, thank you. All right, what are we doing today?
Your Honor, this is a date and time set for a sentencing hearing in this matter. I've had an opportunity to speak with the probation department in this case. Your Honor, a plea was conditioned on Mr. Eckel being admitted into the sobriety court. Mr. Eckel did screen with this court's probation department. Ultimately, on Friday, we were advised that he was not accepted into this court's probation sobriety court program. However, having spoken with Ms. Pilara, it is the understanding of the parties that we would be asking for an adjournment today for purposes of screening with the either 15th District Court or another Washtenaw County District Court for purposes of admission. We do think that Mr. Eckel is a good candidate and can be admitted. So for that reason, we are still seeking admission as we believe that the ultimate benefit of the program has warrants seeking an adjournment at this time.
Check, right, Ms. Pilara?
Yes, Your Honor. I did learn on Friday from the 14A sobriety court that he was not accepted. I did speak with counsel and indicated to him that there is 2 other options in the county that he could try to get into their program. I know that Mr. Eckel did have a couple of appointments in those with ours, and they kind of got bumped down the line. This is why it had to be adjourned. My concern is, and speaking with counsel, this plea was taken with the agreement, is how I read it, that it's kind of contingent upon him participating in the sobriety court. So I would like the court to give this defendant the ability to try to get into one. He did follow through with the screening process. Any delay in that fashion was not on the defendant.
Okay, and I would just indicate, because people have said it different ways, I don't read the plea form that his plea was contingent upon that. What it was is the defendant pled and agreed to enter into the participate in sobriety court. So I don't think it would be a failure of the plea if he does not accept it. Okay, because I think if it was conditioned on that, that would be something different. But I don't read this as saying that he's just agreeing to go in. If they say no, then we've got to figure out something else to do. But, all right. November 16th, December 6th, December 7th. What happened with your testing?
Your Honor, having spoken at length with Mr. Eckel regarding it, those 3 dates, if you notice the times specifically for those 3 out of his windows of the day total, they all occurred when Mr. Eckel was at work. Mr. Eckel does work within the engineering maintenance department of a hotel. The windows that he was just slightly delayed from submitting his test within occurred during times where he was engaged physically in his work. He did then go get his device immediately as soon as he was available. I think his tests are all within 10 to 15 or so minutes of that. We have spoken regarding the need to ensure that it is timely, not just submitted at the about the window. Fortunately, the tests all do come back as negative to verify that he was not consuming. We have spoken. He is going to make additional efforts. For the court's understanding too, I think it's important, as Mr. Eckel advised me, within where he works, there's not a locker or a safe storage area where he can keep his device free from access to others or tampering. So he does have to keep his device in his vehicle. So as soon as he completed an assignment he was working on, did go get it, albeit, as the court can see, about 10 or 15 minutes after the window closed.
Well, no, it's not 10 or 15 minutes. He was half an hour late.
Oh, I'm sorry.
Yeah, it's okay. Same point. I get it. All right.
This is a classic courtroom moment where details matter, and the judge catches it instantly. The defense tries to minimize the delay, 10 to 15 minutes. But the judge corrects it, 30 minutes. That's not a small difference. That's credibility. In court, precision is everything. If your argument relies on minimizing facts and the judge disproves it, your entire position weakens. Then the focus shifts to compliance. The defendant argues that work conditions made timely testing difficult, and that's a real-world challenge. But the court's perspective is different. Rules are rules. If you agree to conditions, you're expected to meet them, regardless of inconvenience. This is where legal reality collides with everyday life. The system doesn't adjust easily. It expects the individual to adapt. So the question becomes, is strict compliance realistic? Or does it ignore the complexities of real life?
All right, just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, so maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway, I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay. All right. Thank you. Court recalls the case People versus Reginald Sims.
Good morning, Your Honor. Justin Zaid, appearing on behalf of Mr. Sims, present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think you know what we need, what else we need to address.
Yeah.
If you would prefer that we address the bond violations first.
We might need to.
Okay. Certainly.
Either way, whatever.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns that it looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a little bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing. Whether before this, after this, at any point in time, I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those and is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
When I look at this, though, I mean, it's a 3-hour window, and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late.
Now the pressure intensifies. The judge lays out the pattern: multiple missed windows, repeated delays. This is no longer about isolated mistakes. This is about consistency. And consistency is what courts care about most. One mistake can be explained. 8 mistakes become a pattern. The defense tries to contextualize it: work schedule, sleep cycle, fatigue. And those are valid factors. But the judge focuses on something else: opportunity. A 3-hour window is not restrictive in the court's eyes. It's flexible. And missing that repeatedly suggests a lack of prioritization. This is where the tone shifts from understanding to accountability. The court is no longer asking, "Why did this happen?" It's asking, "Why didn't you fix it?" And that shift is dangerous for the defendant. Because once the court sees a pattern of disregard, consequences escalate quickly.
In terms of testing.
5 in the morning, and there's 2 tests, there's 6 to 9, and 12. Yeah, so it's 2 months.
Yeah, so, Your Honor, he's working 6 p.m. to 5 in the morning. So basically he gets home and it's testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 a.m. window starts, he gets home at about, 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he could submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 a.m. test.
And then still
12 to 3 is the next one.
And then the next one is 12 to 3. And then he's saying he sleeps during that, gets up at around 5 p.m., gets ready for work and goes to work.
So I get that. So then why is he missing his 9 p.m. test? Which are 3 of these.
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other 2, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 p.m. to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time. Is, like I say, I work, I'm asleep during the 12 p.m. to 3, and I've missed out a few times because I just wake up 15, 20 minutes behind, so forth. But now I'm taking the test, Your Honor. I don't drink.
I mean, I hate to do this, but because if I get, the cold-hearted reality is that these are really violations of tether. It may say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a scram tether going to work better for him? For 30 days that he's going to be on something?
What do I say? Your Honor, I'm just saying, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and I'm always trying to break away, and so I can do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working, and I'm trying to make that time. There are only time.
Well, but you've got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, I'm going to put a scram tether on you, which in dealing with the kids, and I see that is going to be.
This is the turning point. The judge lays out the options clearly, and they are not good. Either the defendant fixes the issue immediately or faces incarceration or stricter monitoring like a SCRAM tether. This is escalation. The court is signaling that patience is running out. What's important here is the judge isn't acting impulsively. He's responding to repeated non-compliance. Courts often give multiple chances, but once those chances are exhausted, the response becomes decisive. And notice the strategic pressure. The judge even points out how a scram tether could affect the defendant's personal life, especially around children. That's not random. That's intentional. It forces the defendant to confront the real-world consequences of continued failure. This moment isn't just about punishment. It's about forcing a behavioral change.
Probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here. 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
Okay. Let me just say, there's a 3-hour window. And you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right? Am I understood?
Understand.
Go ahead, Counsel, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did tender proof of completion to probation, that has been completed as well. I understand that they are recommending the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. We'd ask the court to adopt it.
All right. Sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. Not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day of my accident. I want to take responsibility of that. Due to leadership, I'm part of I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, to tether things like that, yeah, I'm a good citizen. So I don't want to be explaining to these kids like, the breathing. Like I said, I had to run out and do those things. I couldn't do that openly, but, doing positive things, staying active and, I just work, stay active with the children and spend time with my grandkids. So I follow your system. I believe I apologize for the times that I was late. However, I was just late, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time. And I'd like to move forward with you on good behalf.
Who's here with you? Who?
My missus.
Should say that louder.
I didn't.
You whispered it like.
Oh no, I didn't think.
You didn't want anybody to know. I figured that was.
No.
It was.
She's here.
Ma'am, you want him back?
This is one of the most unexpected and revealing moments in the entire session. The judge directly involves the defendant's partner. Why? Because accountability isn't just legal, it's personal. By bringing her into the conversation, the judge exposes something the defense couldn't argue away. The defendant is being reminded at home and still failing to comply. That changes the narrative completely. This is no longer about work schedules or external obstacles. It becomes about personal responsibility, and the judge uses that effectively. He reinforces that the support system is there. The problem is execution. This is a powerful courtroom tactic. It shifts the focus from excuses to reality, and it raises a tough question. When support exists and failure continues, what's the real issue?
Yes, but I'm tired of fucking reminding.
See, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you're talking about what a good an upstanding citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor, so.
Well, hold up.
12
Hold
to
up,
3.
hold up. See, why are you talking? She just told me that she's trying to remind you. She's sick and tired of having to remind you,
Understandable.
right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, ma'am?
Yes.
Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of alcohol. Tell him not to do that. Alcohol highway safety education program and abstinence from all intoxicants for a year. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I'm going to place you on probation for a period of 12 months.
Despite everything, the missed tests, the concerns, the warnings, the court still chooses probation over jail. That's significant. It shows restraint. It shows the court is still willing to give the defendant a chance. But this is not leniency without conditions. The sentence is structured tightly. Fines, programs, testing, abstinence, every aspect of the defendant's behavior is now monitored. And then comes a critical detail: continued monitoring instead of immediate jail time. That's a calculated decision. The court is saying, prove you can follow the rules or the consequences will escalate. This is the final warning stage, because at this point the court has seen the pattern, addressed it, and still chosen to give one more opportunity. The next step, if failure continues, won't be another warning. It will be enforcement.
An order $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Ron, I'll put that.
Pardon?
30 to 45 days. Month.
Did you ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put
Ma'am, when can he get this paid? In a month.
The next month's budget.
Well, no, you know what? You just,
The boss has spoken.
you need to stop talking. I just went to the brain trust. I got it. In a month. So by January 30th?
Yeah.
Thank you, ma'am.
He blamed work, and sleep the judge cut through it. Fast, make the time, or you're going in.
I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Alcohol Highway Safety Education Program. You're to provide proof of the victim's impact panel attendance to probation. That has been completed. I'm going to continue the sober link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir, one thing about me is I've got a very good memory.
This line hits hard, and it's meant to. The judge is making it clear. Nothing gets forgotten. Every violation, every excuse, every missed opportunity, it's all recorded and remembered. This is psychological pressure. The court is reinforcing that future mistakes will not be treated lightly, especially after everything discussed today. And notice how the judge ties it back to the wife's statement. That's deliberate. It removes any remaining excuse. From this point forward, any failure is no longer explainable. It's intentional in the court's eyes. That's a dangerous position for any defendant to be in.
And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her.
This courtroom session reveals a clear pattern across multiple cases: structure, accountability, and controlled leniency. Across adjournments, dismissals, plea deals, and sentencing, one thing remains consistent. The court gives opportunities, but it expects results. We saw defendants walk away with second chances. We saw others face escalating consequences. And in every case, the deciding factor wasn't just the crime, it was behavior. Judge Simpson runs a courtroom where respect, compliance, and responsibility are non-negotiable. Humor appears, but authority never disappears. The biggest takeaway? The legal system doesn't just judge what you did, it judges how you respond afterward. And that response can change everything. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.